Hello and welcome. You guys asked and we listened. You asked for a case on accomplice evidence and here we are giving it to you. Today we're going to be discussing the case of DAGDU and others versus state of Maharashtra. The case was decided on 19th April 1977 and the citation will be on screen. It was decided by a 3-judge bench which was headed by Justice Y.V. Chandrachud. The main issue in this case was whether accomplice is a competent witness and whether conviction can be based on uncorroborated evidence of an accomplice. Let's get to the facts of this case. So let's get into the ghastly facts of this ghastly case. In this case, the accused number 1 was a lady called Rukmani. She was about 32 years of age. She was in her 30s but somehow had entered a period of premature menopause, which means she wasn't able to have children. But she was anxious to have a little toddler of her own. And the accused number 2 in this case is a man called Uttam Rao Bharshate. He purchased a house for accused number 1, that is the lady Rukmani. And they had to live together. They didn't have to live together, they wanted to live together. You know what I mean. So both of them lived together in that house, which became the centerpiece of the conspiracy in this case. Now, accused number 1 wanted children, accused number 2, Mr. Bharshate, wanted money. There was a superstition in their village that there was money or treasure trove buried under trees in many houses, and he wanted to know if there was a treasure trove under the peepal tree in his house. So both of them had their own wishes. One wanted children, other wanted money, and they started doing the obvious thing when you have wishes. Go to quacks or pundits or astrologers or fortune tellers, and that's what they did. So they went to certain quacks. And one of the quacks was suggested a different solution. He suggested that virgins should be offered as sacrifice to the deity of the tree in order to propitiate the deity, and blood from their private parts be sprinkled on the food offered to these deities. And like any normal reasonable person would do, accused number 1 and accused number 2 decided to follow this quack's advice. When I say reasonable people, I'm being sarcastic, so don't leave me nasty comments. Further, moving on. After this quack's advice, 5 small girls about 10 years of age, an year-old infant, and 4 women in their mid-30s were found murdered in that village. And there was a lot of similarities in all of these murders. There were significant similarities in the pattern and the conception, the time and place chosen, preference of females as victims, the nature of injuries, and the strange possibility that their private parts had been mutilated in order to extract blood. The total absence of motive in all of these killings pointed to one fact: accused number 1 and accused number 2, and they did have help from a lot of others, including their servants and many other accused who were also made as accused in the case, but we are specifically concentrating on accused number 1 and accused number 2 today. All in all, 18 people were put up for trial. Now, there were also 2 accomplices in the case, that is 2 co-accused who were made as government witnesses by giving them pardon. One of the accomplices was prosecution witness number 1, who was a man called Ganpat Salve. He was the quack who recommended all of this to begin with. And the other accomplice or the government witness was prosecution witness number 2, who was a man called Shankar. Now he was an agricultural servant of accused number 2, that is Mr. Bharshate. He used to work for him, and Mr. Bharshate said, go kill 4 women for me. So he went and killed 4 women for Mr. Bharshate. Now, both of these were called as government witnesses, and the Sessions Court found accused number 1, accused number 2 guilty of murder and sentenced to death. The High Court, however, reversed the sentence and acquitted accused number 1 and accused number 2. And the matter finally reached the Supreme Court. So let's see what happened in the Supreme Court and what evidence was appreciated and how it was appreciated. Now, accomplice or prosecution witness number 1 was Ganpat Bhagoji, who was the original quack, as I said, who prescribed this entire ritual. Now, the court said that he was a worthless witness whose evidence has rightly been discarded by the High Court. The court said that he was not a quack but a charlatan, and in fact he admitted that he did not have any solution and he made this entire pretense in order to gain money from women who could not have children. His entire story was held to be incredible, and there were many contradictions in his stories. He initially implicated accused number 1 and accused number 2 in search of treasure troves, but later on he said that he had never spoken to accused number 1. He made several significant statements for the first time in the court, and the court said that it's okay. Sometimes all the statements are not made by the police and sometimes they're made in the court for the first time. But if there is so much contradiction between the statement that an accomplice or a government approver gave to the police and then this absolutely different statement that he makes in the court, then there are way too many contradictions to reconcile. So his evidence was discarded. Moving on to the other accomplice, that is Mr. Shankar, who was the agricultural servant of accused number 2. Now he, the court said, was a reliable witness, but he was also a part of every little detail as to the manner of killing, and the court said that it was easy for him to introduce falsities here and there and not give absolutely honest testimony. So it is essential that his testimony is corroborated in material particulars by independent evidence. Unfortunately, there wasn't much independent evidence found. There wasn't any blood found in the earth where the puja was supposed to be done, where they offered blood to the deity. So there was no blood found over there, and there was no evidence of digging. And if accused number 1 and 2 were looking for treasure trove, then they would have tried to dig the earth in order to find the treasure or the money, and there was no evidence of it. Basically, there was no evidence as to the treasure trove story which was suggested by the second prosecution witness, that is Shankar. In this case, hence the court had to discard with the testimony of both the accomplices, the first one because it was absolutely unworthy of any credit with or without evidence, and second one did not find any independent evidence. So both the accomplice testimonies were discarded. There was one confession of accused number 1 which was initially given but later on retracted, and it was also exculpatory, so it did not have much weightage when it came to evidence, hence that was also discarded. Now there was no accomplice evidence, there was no independent evidence, there was no confession. So the courts held that unfortunately in this case accused number 1 and 2 could not be sentenced to death, and they also in part blamed the tardy investigation agency and said that they should have done a better work at investigation in connecting the dots. And because of all of this, eventually it came down to the fact that there was no evidence to hold accused number 1 and 2 responsible, even if they were. And finally, the main point that the court held was that an accomplice is a competent witness, and conviction may be lawful if it rests upon uncorroborated testimony. Yet, the court is entitled to presume and may be justified in presuming, in generality of the cases, that no reliance can be placed on accomplice evidence unless corroborated in material particulars. So basically, as we spoke in the last episode or the last video, that accomplice evidence is good enough, but it depends upon the facts of each case. If you find the accomplice to be trustworthy, go ahead. Uncorroborated testimony, go ahead, convict the accused, and it'll be good enough. It'll be legal, it'll be justified. But if the accused is not worthy of credit, then you have to find independent evidence to corroborate what he's saying. And if you can't find it, then you cannot convict the accused just on uncorroborated testimony of an unworthy accomplice. And the court further held that what is the rule of law is not that conviction is illegal if it is based on uncorroborated testimony, but the rule is that corroboration must be present in the mind of the judge, and if he feels that corroboration may be dispensed with only in peculiar circumstances, then it is safe to dispense with. So it is important that he had it at the back of his mind when he was dispensing with the corroboration part. He felt that this accomplice is worthy, I can go ahead, convict, and that's what important. It's not important that in every case it has to be corroborated, but he must have applied his judicial mind. He must have thought about it while making the decision. That is the important rule of law, that every judge before making the decision has to think whether or not to dispense with corroboration. And that must be followed. So that is that on accomplice evidence. And in this case, as you saw, accused number 1 and accused number 2 were not sentenced to death, but accused number 3 was sentenced to death. And we saw everything that we had to on accomplice evidence. Ciao, till next time.